Good morning and welcome to today's administrative meeting of the Public Service Commission. Before we get started today, I'd like to introduce a few new employees that started with the Commission over the past 2 weeks. The first is Jim McGregor. Is Jim here? Jim's right there. Thank you, Jim. I actually met Jim the other day while I was wandering the halls of the 17th floor. Jim is a former Army officer who joined Staff Council recently, where he was in charge of human resources down in Fort Hood, Texas. And before Fort Hood, he was stationed at Fort Sill in Oklahoma, also working on related human resource matters. He's seen the world. He's been to Kuwait, where he was stationed for some period of time. And now we're lucky to have him here. He has family in Baltimore County and a law degree from the University of Baltimore, undergrad degree from upstate New York at Mount St. Mary's College in Newburgh. So, Jim, welcome to the team. I'd also like to introduce a new engineer that we have, Samrawit Derriere. Is Samrawit here? Hi. She is now one of our new engineers in the engineering division. She started on February 13th. And brings with her some experience from the Massachusetts DPU up in Boston. So we have another fellow PSC alum here. She has experience siting large energy facilities, including power plants, LNG terminals, and transmission lines. Prior to her joining the PSC, she worked for Dominion Energy as an environmental specialist. She holds a chemical engineering degree from Addis Ababa University in the Ethiopian capital, and another degree from Flensburg University in northern Germany in energy and environmental management. Welcome to you. I'd also like to note that in the past few weeks we've taken our enforcement and oversight of supplier issues much more seriously. I'd like to note that on our YouTube channel we've posted a number of customer information videos regarding what supplier energy choice is, how it works, what happens when you have a door-to-door salesman knock on your door in the middle of the afternoon, as well as what happens when you receive telemarketing calls from purported retail suppliers, whether it be legitimate or it be a scam. I've actually received some phone calls recently that were definitely slamming practices. This is something that the Commission is going to be paying closer vigilance on going forward. But I would point anybody's attention to these videos that we've posted. Some of them are a little humorous, some of them are a little corny, in fact, but they're 3 to 5 minutes, but they provide the basics. And I'd like to thank our public relations team and our consumer affairs division for helping get those uploaded. So without further ado, we have a docket today, 9 items on the docket. We have some minutes to approve from the administrative meeting on February 6th that Sue Thomas prepared. Is there a motion to approve the minutes?
Mr. Chairman, I was going to make the motion on this, but then I just realized that I happened to be absent.
You were gone, that's right. Commissioner Linton, maybe it's best if you make the motion.
Thank you. That's fine. Mr. Chairman, I move that we accept the draft minutes for our administrative meeting on February 6, 2019.
Thank you, and I will second that. All in favor?
Aye.
The minutes are approved. Madam Secretary, the consent agenda, please.
Yes, Mr. Chairman. On the consent agenda, there are 2 items. The first item is Connect Energy Group filed on October 9, 2018. Notice that On Demand Energy LP has merged into its corporate parent, Connect Energy, Inc. Second item is Sandpiper Energy, Inc., filed on January 14, 2019. 3 negotiated contracts executed on January 8, 2019.
Thank you. Any questions on these items? Seeing none, is there a motion?
Yes, Mr. Chairman. For item number 1, I'd move that we note the filing. And for item number 2, I move that we accept the negotiated contracts for filing under rate schedule NCR, negotiated contract rate.
Thank you. Is there a second?
Second.
All in favor? Aye. The motions are approved. Madam Secretary, the administrative agenda.
Moving to the administrative agenda, items 3 and 4 are Connect Energy, Inc., filed on November 20th, 2018, request to transfer the electricity broker license currently held by On Demand Energy LP to Connect Energy, Inc., following a merger of the 2 companies. And item 4 is Connect Energy, Inc., filed on December 6, 2018, request to transfer the natural gas broker license currently held by On Demand Energy LP to Connect Energy, Inc., following a merger of the 2 companies.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. These are respectively requests to transfer the electricity and natural gas brokers licenses of On Demand Energy LP to Connect Energy Incorporated. As noted in item 1 of this week's agenda, On Demand has been merged into Connect, which became On Demand's corporate parent through acquisition in late 2018. As a result, On Demand's license must be transferred to Connect if the company is to continue functioning as a licensed electricity and gas broker in Maryland. Staff has reviewed the application and notes that On Demand has no record of prior complaints in Maryland, and that any other states that responded to staff's queries did not have any records of complaints against either company. Connect has met the financial integrity requirement for brokers through the posting of a $10,000 bond. Staff also found that the company's training materials and website did not pose any concerns. Accordingly, staff recommends that the Commission transfer license numbers IR 1442 and IR 3412 from On Demand to Connect. Additionally, the company should be directed to provide marketing materials specific to its Maryland operations to the Commission staff and OPC 30 days prior to using those materials in Maryland. And finally, staff recommends that the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Thank you, Mr. Spivak. For these two items, do the bonds simply transfer, or do they need to repost new bonds?
I think they need to repost the new bonds with the new name. And in fact, I think there was a filing that's intended to do that, or at least that was supposed to change the name on the surety bond.
Okay, Mr. Bonikowski is nodding his head in agreement. Okay, thank you. Other questions? Seeing none, is there a motion for these two items?
Yes, Mr. Chairman, for item number 3, I move the Commission grant the request to transfer license number IR 3412 from On Demand to Connect, and direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff and Office of People's Counsel 30 days prior to the utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application. For item number 4, I move that we grant the request to transfer license number IR 1442 from On Demand to Connect, direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff and Office of People's Counsel 30 days prior to utilization of the materials in Maryland, and finally direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Motions are approved.
Thank you, Commissioners.
Thank you.
Item 5 on the agenda is Alpha Gas and Electric, filed on January 7, 2019, an application for a license to supply electricity or electric generation services in the state of Maryland.
Good morning, Mr. Chairman and Commissioners. Kenneth Albert on behalf of staff. This item addresses a request by Alpha Gas and Electric for authorization to operate as an electricity supplier. Alpha's management has significant experience in the energy industry. We checked their performance in other states, and it was satisfactory. There have been no enforcement actions against Alpha for improper marketing practices. We've checked their website, and that's satisfactory. And the bond, they have posted a bond in connection with the financial integrity standard used by the Commission. Therefore, staff recommends that the Commission authorize Alpha to operate as a electricity supplier.
Thank you, Mr. Albert. Mr. Jang, do commissioners have questions on this item? Commissioner O'Donnell.
Quick question. I note you said in New Jersey the company had a complaint ratio of 0.2% or 0.2% in New York and in New Jersey, excuse me, in both. Give me some context for what that is. What is 0.2%? Is it 0.2% of what, and what does that mean? How should I process that?
Yeah, we typically will do that, Commissioner. Typically, if there's, less than, say, 10, 15, 20 complaints, we consider that low enough to not raise a concern. If the complaint number is higher, 40, 50, 60 up, we want to get it, we want to be able to put it in perspective in terms of, we put in the numerator the number of complaints, and the denominator the number of customers.
I know how to figure out a percentage. You
oh, okay. I wasn't sure you weren't aware how we do it. So our experience has been, if we're seeing it less than 1%, if the absolute number is sort of above the the trigger for raising, triggers concerns, we then say, okay, well, let's put it in the context of the number of customers.
Okay, but still really not getting to the nub of my question, which
Sure.
is, at what level, what percentage level would I say, okay, that's acceptable or that's not acceptable? Give me some context here.
Well, our experience is that any less than 1% is satisfactory.
That's your standard internally? and staff?
We haven't really set it in ironclad rule. It's never been established specifically in precedent, but certainly our experience is less than 1%, and here we're talking fraction of 1%. Our sense is that that's typically a responsible supplier.
Okay, and there's a reason I'm asking these questions. We've been inquired upon recently to kind of justify how we handle supplier complaints in Annapolis, and so these questions are going to be important in our response to that and the perception of how this commission deals with those complaints. I appreciate the math lesson too. Thank you.
Okay. I would note, Commissioner, we also ask sort of informally the staff of the other commissions, even if there hasn't been any enforcement cases, because some states just don't do enforcement cases, though I think because of concerns that are being raised in Maryland and other states, we'll see more of that. We also ask them if this, if off the record, can they tell us that they have concerns about the supplier, even if just at the staff level, such that they are, there are discussions about them. So we do try to take it one more level
Yeah,
than just look at numbers.
We're working on figuring out how to better promulgate our complaints against suppliers here internally and on our publicly available website. So you'll continue to see more scrutiny in this area. So thank you for that, Mr. Albert.
Thank you, Mr. Albert. Is there a motion?
Yes, Mr. Chairman. For item number 5, I move that we grant the company a license to operate as an electricity supplier in Maryland for all customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff and Office of People's Counsel 30 days prior to utilization of the materials in Maryland, and direct the company to file a notice with the Commission within 30 days of any changes to the information in the application.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Item number 6 is Columbia Gas of Maryland, Inc., filed on December 20, 2018, application for authorization to incur long-term debt in the amount of not more than $21 million.
Good morning, Commissioners. Peter Wolson on behalf of staff. Pursuant to Public Utilities Articles, Sections 6101, 6102, and 5203, Columbia Gas of Maryland has applied for Commission authorization to issue up to $21 million in long-term debt in the form of promissory notes to its parent company, NiSource, Inc. The authorization replaces a similar authorization approved by the Commission in 2016, which expired at the end of 2018, and it is needed to continue Columbia's program to maintain the integrity and reliability of its distribution system, primarily by replacing bare steel and cast iron mains with plastic mains through 2019 and 2020. Staff has reviewed Columbia's application and responses to data requests and concluded the authorization is reasonably required to construct, complete, improve, or extend Columbia's facilities, maintain or improve its service, and or reimburse monies expended during the previous 5 years for these purposes. Staff has further determined that the technical requirements of COMAR 20.07.04.02 have also been met. Staff therefore recommends that the Commission approve Columbia's application as requested and authorize Columbia to issue up to $21 million in long-term debt for the purposes stated in the application.
Thank you, Mr. Wilson. Counsel for the utility.
Good morning. My name
Morning.
is Amy Harakis. I'm here representing Columbia Gas. I just want to thank the staff for their recommendation. I have nothing further to add.
Thank you. So as I understand this, Columbia Gas is only issuing a promissory note to its parent. It's not seeking any external debt.
That's correct.
Okay. How often does the utility issue promissory notes to the parent company?
I believe I have a history here, but it's every 2 years.
Every 2 years. Okay. All right. And they're typically for a term of in excess of 20 years?
I don't have that information
Okay.
yet. I'm sorry.
What is the term of this note, Mr. Wilson?
I believe they're asking for a 2-year term.
Was it
That's
2
what the last one was. They've had 5 of these since 2008.
Okay.
And then typically, during that 2-year period, they've been issuing promissory notes up to 4 or 5 to rather than just one lump sum.
Okay, so this is a standard operating practice. Thank you. Commissioners, is there a motion for this item?
Mr. Chairman, I move we grant the company the authority to issue up to $21 million in long-term debt.
Thank you. Is there a second?
Second?
All in favor?
Aye.
The motion is approved. Thank you.
Moving to item 7, Elkton Gas Company filed on January 17, 2019, tariff compliance filing case number 9488.
Morning again, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is a compliance filing by Elkton Gas implementing the rates established in Order Number 89026 at the conclusion of Elkton's recent rate case. The proposed order, the Public Utility Law Judge, issued on January 7, 2019, in case number 9488, became a final order of the Commission on February 7, 2019. The final order authorized the company to implement a rate increase totaling $90,507 and to file revised tariff pages reflecting those appended to the stipulation and settlement agreement as shown in Appendix A of the order. The filing accurately reflects the agreed and ordered tariff changes and rates. Staff recommends the Commission accept the tariff for filing with an effective date of February 11, 2019.
Thank you. Counsel for Elkton.
Excuse
Good
me.
morning.
That should be February 20th.
February 20th, yes. I see the dates keep moving because the administrative meetings keep shifting. Counsel.
Thank you, Mr. Chairman and Commissioners. I'm Carvel Collins here on behalf of Elkton Gas Company. Let me first I want to thank the staff and the Office of People's Counsel for their agreement to the settlement in this rate case. This is the final compliance filing for the tariff, and I'm available if there are any questions.
Thank you. Do Commissioners have questions? Commissioner O'Donnell.
Just quickly, Mr. Collins, the original effective date up to today leaves an incremental value. Do you know what of uncollected revenues? Do you know what that is? Just curious.
A very, very small amount. We think it's less than $5,000. We are awaiting the Commission's decision today before beginning with billing at the new rates. And our plan is to make it effective on February 20th, should the Commission find that to be acceptable.
Thank you. I just want to get a sense of how much we're talking about.
Thank you. A very small amount.
Thank you. Seeing no additional questions, is there a motion?
Yes, Mr. Chairman, I move that we accept the tariff revisions for filing with an effective date of February 20th, 2019.
Is there a second?
Second.
All in favor?
Aye.
The motion is approved. Thank you.
Thank you.
The next item, number 8, is Washington Gas Light Company filed on December 14, 2018. It's revised and power surcharge provision for programs years 2018 to 2020, case number 9494.
Thank you. Again, this is Washington Gas Light Company's revision to its Empower Maryland surcharge tariff. This is the most recent iteration of a filing that was initially made in December and subsequently revised. WGL has proposed to revise its Empower Maryland charge. Unlike the electric company's Empower surcharges, WGL surcharge only includes the costs associated with energy efficiency programs because the company does not offer any demand response or dynamic pricing programs. The proposed surcharges are minus 0.4 of a mil per therm for residential customers and 0.4 of a mil per therm on the positive side for commercial customers. Public Utilities Article, Section 7-211, requires gas companies to develop and implement programs to encourage and promote the efficient use and conservation of energy by consumers. Any costs which are to be included in rates must also comply with the just and reasonable standard of Public Utilities Article Section 4-201. WGL amortizes the cost of the program over a 5-year period consistent with Commission orders. The surcharges are developed based on a revenue requirement that consists of the amortization of program costs, a return component on the unamortized portion of program costs, federal tax credits resulting from the Tax Cuts and Jobs Act of 2017, and a true-up factor that compares the actual revenue requirement based on actual program costs to the actual amount of revenue collected through the surcharge. WGL further proposes to amend its Empower surcharge tariff to require the capital cost recovery factor, that is the return, be computed on the unamortized balance of program costs net of deferred taxes. The company previously did not remove deferred taxes from the unamortized balance of program costs before computing its return component. This proposed change aligns WGL's computational methodology with those of the other Empower utilities. After reviewing the filings and the various corrections, staff has verified that the company has correctly calculated the amortization, return, and the true-up categories for the charges. Staff recommends that the Commission accept for filing the company's proposed revisions to the Empower Maryland charge effective with March 2019 billings.
Thank you, Mr. Spivak. Counsel for Washington Gas.
Good morning, Mr. Chairman, Commissioners. John Dodge, appearing on behalf of Washington Gas. Nothing substantive to add from me. We're happy to answer any questions. I would like to extend our thanks to staff and the Office of People's Counsel for their review and the corrections of our surcharge calculations.
Thank you. Counsel for the People's Counsel.
Good morning, Mr. Chairman, Commissioners. Mikhail Raker on behalf of the Maryland Office of People's Counsel. We have no objections to Washington Gas's currently filing as revised. Just wanted to make one note that we did previously file a letter raising some concerns to the company's previous sets of filings, and we thank the company for working with us to address those matters, and I'm happy to answer any questions.
Thank you, Mr. Raker. No, I recognize that we had this on the docket a month ago. It looks like the utility, People's Counsel, and staff have worked together to correct any inconsistencies or errors. So I defer heavily to staff and their analysis. Do commissioners have questions of this Empower item? No. Thank you. That's a wrap on that one. Is there a motion?
Mr. Chairman, I move we accept for filing the company's proposed revisions to its Empower Maryland tariff effective for meter readings on or after February 27th, 2019.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Motion is approved.
Thank you, Commissioners.
Thank you, Mr. Spivak.
And the last item on the agenda, item 9, is Groundswell, Inc., filed on December 13, 2018, an amendment to its CSEGS application and waiver of deadline.
This is a filing by Groundswell seeking a 90-day waiver of the operational deadline for its community solar energy generation system and notation of an amendment reflecting certain changes in its proposed CSEGs. Groundswell has commission authorization to act as a community solar energy generating system serving low and moderate income customers of Maryland's Community Solar Energy Generating System pilot program. Groundswell's community solar system will be located in Baltimore City, and Groundswell has been selected to participate in the city's Resiliency Hub program due to its location. Groundswell was accepted into the pilot on September 21st, 2017, making its 18-month deadline under COMAR March 21st, 2019. As relevant to Groundswell's request, participation in the program will mean the installation of battery storage and microgrid switchgear on site, allowing Groundswell's community solar energy generation system to operate as planned in usual conditions, but also to use solar backup power in case of a prolonged power system outage. Because BGE's tariff governing BGE's Community Solar Energy Pilot Program does not explicitly provide for battery backup powered resiliency service, the applicant requests an amendment to its CSEGS registration to include the backup power configuration proposed. In addition, Groundswell requests a waiver of the operational deadline in COMAR 20.62.03.04 in order to provide the applicant with an additional 90 days beyond the 18-month deadline set by COMAR to accomplish additional engineering, coordination with BGE, and installation of the equipment required to participate in the Resiliency Hub program. Absent the battery storage unit, Groundswell's community solar facility would operate as planned, but with the battery storage unit, Groundswell will be able to provide power during an outage as well. Staff recommends that under these specific circumstances, the Commission grant Groundswell's request to remain in the community solar program as authorized. Groundswell is effectively providing added value to the community solar program, and potentially the pilot report. Relying on the information provided in the applicant's letter, staff notes that the applicant has experienced some delays due in part to the backup battery-powered resiliency service that they propose, and in part to previous work performed on-site and unrelated to the community solar project. The applicant requests a 90-day extension, which would take its operational deadline to June 19th. Staff recommend that this extension be granted, given their special circumstances. Staff further recommends that the Commission authorize Groundswell to continue in BGE's Community Solar Pilot Program and grant Groundswell a time-limited waiver of COMAR 20.62.03.04C2, extending the applicant's operational deadline to June 19th, 2019.
Thank you, Mr. Spivak. Counsel for Groundswell, good morning.
Good morning.
Do you have anything to add? And if you don't, that's fine too.
No, we're happy to be here and happy to entertain the extension. Some of the circumstances were beyond our control, but we are very excited about this project and its inclusion in the Resiliency Hub program.
Thank you. I do find good cause here shown for the extension. Although I am a little curious, this is the first CSEG project that I've seen that has co-located storage as well. And then we have this other angle where you have a number of subscribers that will not be paying for the commodity. I believe there's 118 subscribers, is that right?
That is correct.
Do those paying subscribers, will they be subsidizing in effect the 35 subscribers that are presumably low income and would not be paying for the commodity?
They're not subsidizing per se. They are paying market rate for their solar power as any other solar customer would pay in a market rate situation. What we're able to do with the financing and the financing partners is enable the low-income participants to receive full benefit of the solar system with no additional cost to the market rate customer for that service.
And this program, did you model it off of another program that's occurring either in the city or somewhere else in the country?
The financing system is something that Groundswell has developed on a national basis, and we've used in other projects. We have projects now in 6 states, and it has modeled successfully. We find that our market rate customers are generally price insensitive as long as they're receiving the value from the solar at less than their native utility rate, which is always part of our system. And therefore we can, instead of giving them full discount, we give them a small discount and use the delta to support our low-income customers in the same system.
Thank you. Well, that does sound like a novel approach.
It usually means we have about 3 market rate customers to every low-income household in our system. That's usually the ratio.
So in other projects in your portfolio, you have a similar situation where you have non-paying customers or deserving customers?
Yes.
Okay. I'm sorry, for the record, what is your name and title?
I'm Christina Nichols, and I'm the Senior Program Manager for Groundswell. I'm not of council, but I'm here representing Groundswell. And my colleague Nina Lobo is also with Groundswell.
Thank you, Ms. Lopel. Commissioners, questions? Commissioner O'Donnell.
Just quickly to staff, is there any concern that we're setting precedent with this kind of project? This is the first one of these I've seen that incorporated storage. Any legal concerns?
I don't think we have that kind of concerns. In terms of setting precedent, this might be a good one to set. Certainly the storage is something that we do feel adds some value to the project. And in terms of this being a pilot program, it adds value to the pilot because it gives us the opportunity to evaluate that particular aspect of a system and see how useful it is. So I think there's actually a positive possibility of a precedent there. As far as the precedent in terms of granting the additional operational deadline extension, again, this is kind of a sui generis situation. It's not something that we're going to see a lot of. So I don't think there's too much of a concern there, but each request obviously gets evaluated on its own individual merits.
So we don't anticipate seeing an endless stream of requests for modifications to add storage to, and the attendant delay that we've been seeing.
I don't think we anticipate that, but that is a bridge we'll be prepared to cross if it does.
I'm not sure it's
Show
a
up
bridge
in front
I'm
of us.
prepared to cross.
Yeah.
But, okay, I do see value in this. Obviously, it's a direction that we're going to head with solar, and it's a good way to test it, and, I don't have a problem with it. To the company, I wanted to ask, have you experienced any construction delays? Kind of allude to generally other work that happened unrelated to this project, but
No, this is unique to this particular site, and it doesn't have anything to do with the solar engineering or technical materials around the solar, or even the storage. Is a soil issue at this particular site that we have to mitigate before we can proceed with some of the installation of batteries and switching gear.
is this a brownfield site?
Yes.
Okay, all right, that kind of makes sense to me then, but you have had no weather-related delays?
No.
Interesting. Okay, thank you.
Thank you. Thank you, Commissioners. Yes.
I just had a couple of questions about your response to the staff data request item number 5 regarding the manner in which you'd be selecting the 35 low and moderate income customers. I was just curious, are these customers, since you're using the Empowerment Temples network to announce the program, are these low-income customers that are determined low income by the state or by the Empowerment Temple?
It's by the state. We want to benefit residents of the nearby community, of course, but the Empowerment Temple agreement is simply to serve as the host site for the installation and to serve those deemed low income by the state of Maryland's guidelines.
So
Within the general, Baltimore City certainly, but nearby, hopefully.
So are you working at all with the Department of Human Resources?
Yes.
Oh, you are? Okay.
Yes.
Okay. All right, thank you.
Thank you.
Thank you. Seeing no additional questions, is there a motion?
Yes, Mr. Chairman, for item number 9, I move that we grant the company authority to continue in BGE's Community Solar Pilot Program and grant Groundswell a time-limited waiver of COMAR 20.62.03.04C2, extending the application's operation deadline to June 19th, 2019.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Thank you, Commissioners.
Thank you. And seeing no additional business before the commission today, have a great day. This meeting is adjourned.